Good morning. Just wanted to make a short little video this morning to help you guys out in court. Take it with a grain of salt. Do your own research is always encouraged. Listening to people who have firsthand experience and knowledge to walk into these courts is always important. Their trials, tribulations, and testimony with firsthand perfected knowledge of what transpires in these courts is always of great value. I've found a number of men and women that are like myself that do go into these courts while others preach about staying out of them. There are a number of us that we do best under pressure, and we understand that freedom isn't free. Can you do it with paperwork? Yes, you can. If you're not well versed and well spoken, paperwork would be your best option because you don't have to worry about being intimidated. So, in a court case that involves no real party in interest, I'm just going to run through a number of things that will benefit you as acquired knowledge that I've gained throughout my years of doing this. And remember, I don't just involve myself or subject myself in the cases against the all caps name that resembles mine under the doctrine of idiom sonum. I also subject myself to helping others in their court endeavors as well. I was just recently kicked out of a courthouse, which tells me that facial recognition is in almost every courthouse because I'm not even in the same state, nor do I frequent that state. And I was removed from the courtroom almost immediately after I sat down, which tells me they're using facial recognition. They know who I am. This is not the first time this has happened. It also happened in Perrysburg, Ohio as well, where I no more than walked in the door and they're like, "You don't have business here. We got somebody coming down to take care of you." I said, "Do you know who I am?" They go, "Mr. Gonzalez, we are very aware of who you are." So it just goes to show when you have a number of platforms and over, like 17,000 followers at this point, once you start to make a name for yourself against the cretins who seek to fleece the American people, you will become a marked man or woman. So ye be warned, this stuff is not taken lightly. And when you start meddling with their bank accounts and with their finances, they'll do exactly what they did to Martin Luther King, JFK, and a number of other people. It's just how it is. So I don't do this stuff lightly. I know it comes with great risk, but also the people of the world deserve to know what the hell's really going on. So with that said, for those of you that are involved in court cases, and I don't care what point or what stage of the court case you're in, jurisdiction can always be challenged. The common misconception is that you challenge jurisdiction by walking into the court and saying, "I challenge jurisdiction." That is not how you challenge jurisdiction. And I myself am guilty of once upon a time thinking that was the proper way to assert myself, to challenge jurisdiction. But simply stating that doesn't challenge jurisdiction at all. In fact, you have to understand how to challenge jurisdiction and why you're doing it. First of all, when you walk into a courtroom, you bear full liability, even up into death, okay? Because the law provides that it is enforceable by lethal force. All orders can be enforced by lethal force, okay? Now, there's an important point that I want to make here. If all laws and orders can be enforced by way of lethal measures, then the plaintiff also would have to be bearing the same burden. How do you kill the state? Can't be done. All right, it's a piece of paper. It's nothing more. So if I'm risking my entire life, the plaintiff on the other side needs to also be doing the same. It's a well-established fact that all parties must be clearly identified in a court, just for that reason, because the liability includes death. All right? So I see no plaintiff making a general appearance sworn to, independently bonded, sworn to a statement under the pains and penalties of perjury, and I believe none exist. That statement makes it a matter of law. All right? No more presumptions and assumptions. I want to know who is invoking this court's jurisdiction. That question should probably be asked first, right out the gate. How do you plead? I need to ask a few questions here for clarity. Who's invoking this court's jurisdiction? Where's the man or woman, the claimant on the other side here, invoking the jurisdiction of this court, and why are they not here? That fallacy of 11th Amendment qualified immunity dissipates in the wind. Gone. The judge no longer has plausible deniability. Okay? All men are responsible for knowing the law, thus ignorance of the law excuses no man, especially a learned man who went to law school and then was groomed to be a judge. Period. If you're not excused from knowing the law, they damn sure are not. All right? So listen to what I say very carefully and closely, and apply it with conviction. Because you cannot be jailed for asking questions. You have a right to be fully informed of the nature and cause of the action. All right? Who in this court is invoking the jurisdiction of this court? Where's the claimant? See, without that man or woman on the other side, you're the only one risking it all. They're gambling. They're gambling on the fact that you will never figure this shit out. They love the fact that you spend your countless hours and days on end studying statutes, codes, city ordinances, rules, and regulations. They just are absolutely in love with the fact that you chase that fallacy down as though somehow it's relevant. Because in reality, in order to invoke the jurisdiction of the court, there must be either like entities going head-to-head, corporation versus corporation, or man versus man. Period. Only a man can invoke the jurisdiction of the court. Now, when entities are going at it, they have to have lawyers, okay? Because that's their realm. That's their commercial realm. But mano a mano is a different story. Think of it like Judge Judy. That's man versus man. It's more of an equitable setting. If there could ever be articulated an equitable setting, it would be like Judge Joe Brown, Judge Judy. Those are really equitable courts. You don't ever see anybody representing themselves. They are who they are, and they're telling their story, and they're allowing a third party to decide what the remedy or outcome should be based upon the information provided and the evidence subjected to the court. So the plaintiff in Judge Judy is the one invoking the jurisdiction. Not only that, but before you end up on a show like Judge Judy or Judge Joe Brown, you have to sign a contract granting them the authority and consenting to their jurisdiction. All right? When's the last time you had to do any of that in a public for-profit setting where the banker sits on a bench? You've never had to do that. But on Judge Judy, Judge Joe Brown, you do. They're looking for a claimant. The prosecutor doesn't have any first-hand knowledge of anything, and Trinsley versus Pagliaro clearly states that hearsay cannot be utilized in a court in order to reach a declaratory judgment or a summary judgment. So anything that pretend lawyer says is moot. It has no relevance, it has no bearing, and it has no weight because he is not the claimant. Now, if he wants to claim to be the claimant, now you have fraud on the court. Why? Because he doesn't have any first-hand knowledge of the facts. He wasn't involved in the scenario. He read something to be true, but he doesn't know it to be true. It's nothing more than hearsay. He used an officer's statement or probable cause affidavit, which is hearsay, okay? And he's trying to move forward on behalf of the state, a fictional entity, to fleece you of what rightfully belongs to you, which is your life source energy, your time, okay? Some of the next questions would be, where is the claimant? When can I meet the claimant? When can I depose the claimant? They'll try and lead you to believe, well, let me just read you your rights here before we get too much further into this. No, that's not necessary. I'm not going to grant you jurisdiction in this venue. You don't have an opposing party, and unless the real party of interest is here, this need not go any further. And remember, ladies and gentlemen, you can challenge jurisdiction even at sentencing, okay? If there's no plaintiff, there's no case, period. They're looking for you to make a claim, because as soon as you make a claim, now there's controversy. The only thing a ministerial administrator is in the room to do is to rule on controversy. And if you go in that room and you claim that name that rightfully doesn't belong to you, it belongs to the United States, now you've created a controversy. Now you have the onus of probandi put on you to prove that you own that name. I've been known to use it. But far be it from me, I don't know who owns it and who carries the full weight and liability of it. Well, are you or are you not Derek S. Gonzalez? Can one be a sound? Can one be a name? I just need an answer. It's taken a lot of years for me to get to this point, and I'm just flabbergasted with how simple it really is. Because naturally, I wanted to believe that it was so complex, but it's so simplistic, it's beautiful. And if you can just follow this, it's so simple to walk out that door. Let them settle their affairs. Get out of their way. They're banking. That's what they're doing. Okay, they're creating negotiable instruments. Yes, do you have a vested interest in said securities? Sure you do. That's for another day, another time, and another place. In that venue at this moment, the only thing I want you to do is walk out of there with a clean and clear conscience, knowing you did the right thing. And the right thing is to comprehend that you own nothing in this world. You don't even own your body. It belongs to the world. From dust you come and dust you shall return. It's not yours. The living spirit, sentient being within you, within this meat suit, belongs to the Heavenly Father. All right, and you can't serve two masters. It's blasphemy to claim something you don't own. And people want to argue and they go, well, Derek, my mother gave me that name. No, you have a calling. You may answer or respond to it, but let me ask you this. How many callings do you answer to? See, my sister calls me brother. My mother calls me son. My ex-mate calls me asshole once in a while. I respond to all of those. Do I own any of those? No, I do not. Am I known to answer to them from time to time? Sure I am. But the owner bears the liability. The owner comes in as surety. So who's the claimant in this matter? Making controversy. Can they come forward? When can I meet the claimant? When can I depose the claimant? Well, sir, the state is being represented here. I could give a shit less about the representation. I could care less about that. That man better produce his claimant. He better show his warrant of attorney. Where is his warrant of attorney on behalf of his client? Where is it? And why isn't it before this court? I see no facts and evidence to the contrary and believe none exist. Make it a matter of law. Tie the judge to his seat. Bind him. Make him liable for participating in a conspiracy against your unalienable rights.